We all have heard of trials. We have studied them, but at the end of the day, we are a little bit confused about it, isn't it? Because we do not focus on the root level. But do not worry, because this video going to deal with pre-trial proceedings, which will enhance your ability to grasp the procedure of trials more efficiently. But before we go further, check out our Android app. You can find our videos easily over there. So let us come to the topic. I had divided the pre-trial proceeding in 3 parts. The first part is where the cognizance is taken by a magistrate, which is provided under section 190, which we will going to study later in this video. The second one is the extension of the first point, which talks about proceeding of complaint under section 200, 203, 209 and much more relative sections. The third part is the creation of the charge, when the magistrate creates a charge on the accused person. So in this video we will going to deal with the first point, and it deals with section 190. It talks about that a magistrate may take a cognizance of an offense on 3 things. The first can be a complaint, the second can be a police report, and third can be the information received to the magistrate by any person, or even the magistrate himself can take the cognizance. There are few words that we have to understand carefully, like magistrate. Magistrate word includes magistrate of first class and magistrate of second class, which is empowered especially by the chief judicial magistrate. The another word is may. The may word is very important, as it must be read as mandatory, as it is stated in the case Sampat Singh versus State of Haryana. You can view this citation in the description box. The third and important word is cognizance. What is cognizance means? Cognizance merely means becoming aware of. So whenever a magistrate make himself aware of the complaint, police report or any information given by person, it's said to be a cognizance taken by a magistrate. The police report on which a magistrate can take a cognizance, that police report can be either based on cognizable offense or on non-cognizable offense as well. If I am correctly assuming your thoughts, there must be a question in your mind that what will happen if a magistrate is taking a cognizance on which he is not authorized to take. So there are only 2 conditions possible, that magistrate can either take a cognizance in a complaint or on police report, and if he took that in good faith, it will not violate the proceeding. Proceeding will be a valid one. But if a magistrate takes a cognizance on the third point, means the point where the information is received by any other person, or even the magistrate himself take cognizance on his own opinion, then proceeding will be void from the starting. It is also mentioned under section 461K of CRPC. That's all with section 190. Next video will cover the complaint to magistrate with relevant sections. In the end, I just wanna thank you, all of you, for showing your support and keep supporting me. If you like this video, give it a thumbs up. I will meet you in another video. Till then, goodbye.